Sharia, as practiced in pre-colonial Muslim societies in West Africa, is totally different from the modern conception of law. Modern law is produced and implemented by states, institutions, and applied to all citizens. In contrast, the state had virtually no involvement in the elaboration, interpretation, and implementation of Islamic Sharia, simply because the state as we know it did not exist in the Muslim world. Where states existed, they might have appointed judges and defined their area of jurisdiction, but the law itself was produced by muftis in the pre-colonial times in the form of fatwas or proclamations, through which these muftis answered questions coming from other judges or private individuals. In their fatwas, muftis stated what in a specific context was in conformity with the teachings of the Quran and the traditions of the Prophet Muhammad. A central feature of the Sharia is legal pluralism. Even within the same school of law or madhab, a variety of opinions may coexist on the same legal issue. In addition, fatwas given by muftis were not binding on individuals or judges, although they were often followed. The absence of impersonal law to be implemented on all individuals created great flexibility for the muftis. The judge or qadi enjoyed a considerable autonomy to adjudicate disputes on a case-by-case basis. Subscribe on Tarihi channel for more interesting and educative videos on African history. The study of law or fiqh was at the heart of medieval learning in the Muslim world. The reason is that Sharia provides guidance on all aspects of life, from rituals such as purification, prayer, fasting, performing pilgrimage, to commercial transactions, family law, which involves marriage, divorce, child custody, criminal law, and law governing the administration of state or the conduct of war. Understandably, the study of law was central to the medieval curriculum everywhere in the Muslim world. As one of the oldest branches of learning, Islamic Sharia grew to become a complex field subdivided into many subfields and including the study of sources known as usul fiqh, schools, mazahib, didactic texts, legal maxims, qawaid, and legal cases and opinions, fatawa, and nawazil. In Muslim schools, beginners were taught elementary didactic Maliki texts, whereas foundational texts and other advanced manuals were used for advanced juridical training. The most used didactic fiqh text in Western Africa are the Mukhtasar fil Ibadah, a brief treatise on worship by Abdul Rahman al-Akhdari, and the Muqaddimah or introduction by the 16th century scholar Abdul Bari al-Rifa'i al-Ashmawi. Typically, these books are referred to as by the names of their authors, al-Akhdari and al-Ashmawi. Copies are found in many collections and they are available in Islamic schools in the whole West African region till today. For advanced legal studies, students were taught foundational texts dating from the formative period of the Maliki jurisprudence, such as the Muwatta, the well-trodden path, written by the founder of the Maliki school, Malik bin Anas. Copies of the Muwatta are found in most library collections. The Timbuktu scholar Ahmed Baba mentions it as one book that he studied with Bakayogo Wangari in the 16th century. We also know that the Muwatta has for centuries been one of the three key texts used in training of the Jahanke clerics. The second important foundational text of the Maliki jurisprudence in the Sahel was the Mudawwana of Sahnun. Although less used, the Mudawwana was complementary to the Muwatta. In addition to this foundational text, later generation manuals of jurisprudence were also taught in the Bilad Sudan. These include the Risala or Epistle of Ibn Abi Zayd al-Qayrawani, the Mukhtasar, the concise treatise of Khalil bin Ishaq, a text so dense that it was typically taught with the aid of a commentary, the Tuhfat al-Hukam, a gift for the judges by Ibn Asim, and the Irshal al-Salik ila Ashraf al-Masalik ala Madhhab al-Imam Malik, guiding the aspirant in the most noble paths of the school of Imam Malik by Abdul Rahman bin Askar al-Baghdadi. The last category of advanced legal texts with which Sudanese scholars might have been familiar is the compilation of legal cases and opinions, fatawa and nawazil. For centuries, the most comprehensive of such texts in the Islamic West was the Ma'yar standard of Al-Wansharisi, which is a large compilation of legal opinions produced between the 9th and the 15th centuries. Only 2 copies of the Ma'yar are found in the Mauritanian collections. Ahmed Baba states that he read the entire Ma'yar. Likewise, Usman Danfodio, making the case for the obligation to migrate from the lands of infidels back to the land of Islam, backs his claim by appealing to the Ma'yar among other sources. This suggests that the Ma'yar as an advanced text was taught in the Bilad Sudan, and zealous students who to have known with whom to study it. Jurisprudence or fiqh was important for religious life because devout Muslims wanted to perfect their religion, and whenever confronted with a precedent, would approach jurists to guide them in the right path. Jurisprudence was also important for economic life because Muslim merchants, particularly in major commercial towns such as Timbuktu, Kano, Shanqait, and Walata, were not just driven by the search for profit. In principle, at least, they wanted to make lawful gain, kasb al-halal. As to the issue of slavery, there were rules that governed enslavement and ownership of slaves. Jurists and judges would arbitrate between conflicting claims. Jurisprudence was also important in political life, and some rulers sought advice from leading Muslim scholars on how to deal with important issues related to statecraft.